So thank you for having me today. Thank you to Anthony for everything you've done with Robina Institute, and thank you all for coming. So I've got 15 minutes and I'll get started. If I could change just one thing about the criminal law, I would stop criminalizing victims of sex trafficking. Instead, I would use those resources to focus on the pimps who are benefiting from sex trafficking, and I would criminalize the buyers who are creating the market demand for the commercial sex industry within which sex trafficking flourishes. But that's 3 different proposals, and so I'm just going to focus on one because I follow Anthony's orders when he gives them to me. In the time that I have here, I'm going to try to answer 3 questions about this one single reform to the future of the criminal law, decriminalizing sex trafficking victims. First, I will address the question of who are sex trafficking victims? What are we talking about here? Second, I will explain why we should decriminalize victims of sex trafficking. And then finally, I'll survey a number of ways in which we might accomplish this goal and recommend one of the particular ways as best. So first, who are the victims of sex trafficking? Let me just start by admitting that this, in some circles anyway, this issue is fraught with disagreement at the margins. And when I say at the margins, I mean in the relatively rare cases of women who appear anyway to be freely choosing prostitution as work. And academics love to debate the margins. We love it, especially philosophers. And I've spent a good deal of my own academic time examining concepts that arise at the margins, such as what counts as genuine consent in this context, and what difference does consent make, and what counts as coercion. So all of these issues do exist at the margins, but today I want to focus our attention not on the marginal cases, but on those cases where there is wide agreement that, in fact, sex trafficking is taking place. So first, it's widely agreed that prostitution of someone under 18 years of age counts as sex trafficking. The 18-year age-based cutoff is a bright line that is broadly accepted in international law, in U.S. domestic law, in the laws of many states. And it also forms the basis of U.S. foreign policy as well, in addition to some other things I'll mention in a moment. And quite simply, throughout the world right now, it is becoming increasingly well recognized that there's really no such thing as a child prostitute. Instead, these children are victims of sex trafficking. So, by definition, prostitution under 18 counts as sex trafficking. Another clear point of agreement is that any adult who performs a commercial sex act that is induced by force, fraud, or coercion is a victim of sex trafficking. And this is the definition of severe forms of sex trafficking taken from the United States Trafficking Victims Protection Act. So it is incorporated into our federal law, many state laws, and again, it forms the basis of U.S. foreign policy on this issue. Now, there's a somewhat broader definition of what counts as sex trafficking that we can find in international law. Specifically, the United Nations Anti-Trafficking Protocol, which is the first and only international law that defines sex trafficking, uses a somewhat broader definition. It covers all child prostitution, and it also covers the cases of force, fraud, and coercion, but it also includes cases where adult prostitution is induced by means of power or a position of vulnerability. So to review, all so-called child prostitution is sex trafficking. All cases of adult prostitution involving force, fraud, or coercion is widely accepted as sex trafficking. And indeed, for the most part, now I'm quoting the UN Special Rapporteur on Trafficking, for the most part, prostitution as actually practiced in the world usually does satisfy the elements of trafficking. It is rare that one finds a case in which the path to prostitution and/or a person's experiences within prostitution do not involve, at very least, an abuse of power or a position of vulnerability. So moving on, why should we decriminalize victims of sex trafficking? There are 3 main reasons why. One reason is that our failure to do so likely violates our obligations under international human rights law. Indeed, just last month, the UN's Human Rights Committee expressed concern that the U.S. is not complying with our treaty obligations under the International Covenant on Civil and Political Rights due to our continued criminalization of victims of sex trafficking on prostitution-related charges. the UN committee urged the U.S., and I quote, to take all appropriate measures to prevent the criminalization of victims of sex trafficking. As leading human rights scholars have recognized, this action by the UN sends a clear message that victims of trafficking are having their fundamental human rights violated by our practices. And I might add that it seems that we're also breaching our obligations under international human rights law by continuing to criminalize them. So that's one reason. Another reason we should decriminalize victims of sex trafficking is that we tell other countries to do so. For nearly 15 years, the U.S. has served as the world's most powerful monitor of trafficking in persons, with the annual publication of the U.S. State Department's Trafficking in Persons report. The report ranks countries throughout the world on a multi-tier system according to their compliance with what we call minimum standards for the elimination of trafficking in persons. If countries rank highly, they remain in good standing with the U.S., and they receive our praise for appropriately tackling human trafficking. If countries rank poorly, they face a range of negative consequences, including the imposition of unilateral sanctions by the United States. So one of the items we measure in this report we put out every year is whether other countries have successfully ensured that victims of trafficking are not, quote, inappropriately incarcerated, fined, or otherwise penalized solely for the unlawful acts they commit as a direct result of being trafficked. So we judge and sanction other countries for doing what we ourselves continue to do throughout most of the United States. This is hypocrisy on a global scale. Finally, we should decriminalize victims of sex trafficking because it's the right thing to do. Aside from the massive waste of resources that could be far better spent funding John's programs, where did he go? John's, far better spent combating traffickers or other criminals, funding education and healthcare, building bridges or roads or goodness knows what else. Even aside from the economic considerations, we simply have no justification for criminalizing victims of sex trafficking because typically they're not blameworthy for what they've done. And the criminal law condemns actions and actors, labeling them as blameworthy and worthy of condemnation. And as such, it is only proper to use this tool to target those who have engaged in serious wrongdoing and who are genuinely blameworthy for having done so. But in prostitution cases where children are being exploited or where adults are being subjected to force, fraud, coercion, or an abuse of power, an abuse of their vulnerability, and there's simply no justification for criminalizing these victims. So how should we go about decriminalizing victims of sex trafficking? In this final section of my talk, I'll briefly outline 4 possible methods of decriminalizing sex trafficking, highlighting the problems with the first 3 and recommending that we adopt the 4th. So one way to decriminalize sex trafficking victims, which is gaining some traction in the US, and John mentioned it earlier, is to enact so-called safe harbor laws that call for protection rather than prosecution of child victims. And I just want to give a shout out to Minnesota. God bless you people. You are so good on violence against women. You got the Duluth Model for domestic violence. You're out ahead on issues of decriminalizing sex trafficking. I mean, if anybody in the audience is working on these issues, please introduce yourself to me because I'd love to thank you and shake your hand. So Minnesota is really a leader in this, and I feel like I'm cheating by preaching to the choir by coming to Minnesota to give this talk. But trust me, if I gave the same talk in my home state of Pennsylvania, people would look at me like I had 3 heads. So you all are out ahead of it. So safe harbor laws are great, but they remain incomplete. They remain incomplete in the sense that only 18 states have adopted them. They remain incomplete in many instances because they do not entirely decriminalize all sex trafficking victims under the age of 18. Minnesota does, but many, or will as of August of 2014 when it comes into effect. But many states have implemented more of a diversionary program, and they call it safe harbor, where by default the juveniles are still treated as criminals, but they have the option to divert out of the criminal justice system. And finally, safe harbor laws, they remain incomplete because they do nothing whatsoever to decriminalize adult victims of sex trafficking. And this fact is particularly troubling given that the majority of victims of sex trafficking were first prostituted as children. So even in a state with a safe harbor law in place, people can go from being recognized as a victim of sex trafficking on one day, namely the day before their 18th birthday, to being treated as a criminal the very next day. So in that sense as well, the safe harbor laws are a good step in the right direction, but they're woefully incomplete. A second method for decriminalizing victims of sex trafficking is to rely on police and prosecutors to identify victims and exercise their own discretion to decline arrest or prosecution. And this method is certainly an improvement over the still all too common law enforcement strategies that focus on arresting victims. But again, the approach does too little, too late. First, there remains a very high risk that law enforcement will fail to identify prostitution cases as cases that are actually involving trafficking. And in any event, only 29 states even provide law enforcement training to assist officers in identifying trafficking cases. So really, this approach does too little to combat the problem. Second, by the time law enforcement is in a position to screen a particular case to determine whether the person who has been arrested or charged is actually a victim of sex trafficking, the person has likely already been subject to arrest, interrogation, and perhaps even detention. So this method, while it marks somewhat of an improvement on standard methods that are still in place throughout much of the country, it really comes far too late in the process as well. A third option is to decriminalize everyone involved in the commercial sex industry, including the seller, the buyer, the pimp, and the brothel owner, etc. Variations on this approach have been adopted in countries such as the Netherlands, Germany, parts of Australia, and Las Vegas, somewhat. While levels of attempted regulation vary from place to place, the key similarities to this approach is that prostitution and related activities are regarded as legitimate forms of work. So this method, while seemingly promising at first glance, it fails to provide a plausible solution to this problem. Instead, it comes with a heavy cost of increasing the overall amount of sex trafficking in the jurisdiction due to the increased demand for commercial sex that results when prostitution is normalized through legalization. As a recent empirical study of 150 countries demonstrates, and I quote, "Countries where prostitution is legal experience larger reported human trafficking inflows," which is to say, legalization of prostitution across the board increases sex trafficking. So that brings us to the fourth option, the so-called Nordic Model. It's a combined approach that decriminalizes people who sell sex while providing comprehensive social support programs for those who wish to exit the commercial sex industry. By implementation of this model, countries such as Sweden, Finland, and Iceland have managed to decriminalize sex trafficking. And they've managed to do so without the unintended effect of increasing the amount of sex trafficking that results from legalizing prostitution across the board. Research regarding the impact of the Nordic model demonstrates promising results, with studies reflecting dramatic decreases in prostitution across the board. Now, it should be noted that supporters of the Nordic model often invoke additional claims regarding the nature of prostitution, such as the claim that all prostitution is violence against women. And indeed, this view has widely informed and motivated the adoption of such laws, so that's true. Yet even if one rejects that view, the evidence is clear that the Nordic model achieves two important policy goals. Number one, it decriminalizes victims of sex trafficking. And number two, it does not result in an increase in the total amount of sex trafficking in that jurisdiction. On these grounds alone, the Nordic model presents a far more attractive model than legalizing prostitution. So in conclusion, just as the 1-minute sign goes up, thank God, the U.S. should decriminalize victims of sex trafficking. Our current practice of arresting and prosecuting victims for prostitution-related offenses is not only a profound injustice, it's likely a violation of our obligations under international law, and at very least, it is an embarrassing hypocrisy. We should move swiftly toward decriminalizing all victims of sex trafficking, child and adult, and we should do so in a way that does not result in an overall increase in sex trafficking. In sum, we should decriminalize victims of sex trafficking by adopting prostitution reforms based on the Nordic model. Thank you.